Hi, and welcome to Behaviour Bond Lawyers. Today, we are going to look at drink driving offences in New South Wales. Welcome to Behaviour Bond Lawyers. Thanks for coming along to beasleyborman.com.au. Today, I want to discuss with you a matter that I represented or appeared on this morning at Waverley Local Court, just near Bondi Junction. Waverley Local Court is a relatively small court. It has two courtrooms and it deals with all of the criminal matters that occur in the eastern suburbs and much of the southern suburbs around Sydney. The charge that I appeared on today was a high range PCA or drink driving charge, and basically this is a very serious offence where the blood alcohol reading is above the 0.150 level, and in fact for my client today, his reading was well above that high range threshold, as it was 0.180. But what made this matter far worse than a standard PCA or drink driving matter was the fact that there were a number of serious aggravating features involved in this matter. Now, an aggravating feature is a feature or a fact or aspect of the incident or the offence which occurred, which basically puts other people at greater risk of injury or death due to the person's offending behaviour. And in this particular situation, the blood alcohol reading at 0.180 was a definite aggravating feature, and the other aggravating feature was that my client was involved in a car crash. He had crashed or collided his vehicle into a parked car, into two parked cars actually. One was a complete write-off, and the second car there was some minimal damage. He'd also written his car off, so it was quite a serious end to the very foolish actions that he took to get into his car after he had consumed far too much alcohol. In preparing the case, we had to carefully consider the situation because of the seriousness, and we got our client along to obtain some professional psychological help from a psychologist. He attended a number of sessions where he was able to get help in dealing with a number of mental and emotional issues that he had been going through for some time, which led him to drinking alcohol far in excess of what he usually would. He attended a number of sessions, and the psychologist prepared a report which we delivered to the court, and also indicated to the court that he had put in place a future mental health care plan for my client to carry out into the future. Other things that we helped our client prepare for in order to present the case to the court was we got our client along to do a traffic offenders program. He attended the Eastern Suburbs Police Citizens Youth Club, which holds an approved traffic offenders program. This was the fully approved 6-week course that he went to, where he attended one night a week over a period of 6 weeks. It's a very worthwhile program. It's approved by the court system and the Attorney General, and it certainly holds a lot of weight in court. My client was then able to turn around and present a letter of apology to the court, just giving the court a little bit of insight as to what went wrong on the night, and also the significant lessons that he had learnt after having completed the traffic offenders program. Other references that we did tender to the court was some personal references which spoke highly of my client, and also some reference or statements from his employer to show the court that he would struggle to perform his work without the use of a motor vehicle, and also just to show the court that he is a person who is well regarded in the workplace, and that he does have stable employment. So these were all very important pieces of material and evidence that we were able to collate together and present to the court. I was also able to stand up and speak on behalf of my client and give the court a little bit of insight as to what had been going on in my client's life, which had really led him to make this poor decision. He had been going through some very trying times over the last couple of years after having gone through a messy divorce and having several problems to contend with his own children, and certainly him going along and getting some of his own psychological help is the right step forward from now and into the future. And the court could see that he had taken positive steps to get his life back on track. I was also able to explain to the court that my client's car was a write-off. The car that he crashed into was a write-off. He's been charged with a criminal offence of drink driving, so there's going to be no insurance forthcoming to pay for the damage caused. So my client is going to be at least $40,000 to $80,000 out of pocket, and with no assets, with no car. So this has been an extremely expensive lesson for my client to learn. But he was the first one to put his hand up and accept full responsibility for his stupid behaviour and his foolish actions. And the court was able to see that he was displayed a strong element of contrition and remorse for the actions that he did take on the night of the incident. The court was also able to accept that he now had an understanding of how dangerous his actions were that he took on that night that he was involved in the car crash. They were able to accept the financial, emotional and physical hardship that he is currently going through, having to make those payments for the damage done, having to now catch public transport in order to get to work, which means he does have to carry and lug around a large amount of tools and equipment with him. It's very difficult, very inconvenient, and a very tough period for him. The court was able to accept that. But the court did have to make appropriate penalties in this case because it is such a serious matter. Generally speaking, when someone passes the threshold of a high range PCA, the guideline judgment will kick in, and this is a judgment which has been handed down from the higher courts, which is just a guideline for the lower courts, like the local court, to give them a guide of how to handle serious high-range drink driving matters like this. It outlines what a standard a high-range drink driving matter is and what sort of aggravating features can make the matter more serious. And obviously, for my client, unfortunately, there were the two big aggravating features of his blood alcohol reading, and also the fact he was involved in a car accident. A saving grace for my client was the fact that he didn't have any passengers in the car at the time, and also the fact that he crashed into a parked car that had no one in it. So whilst it was a very serious matter, there was a significant less risk of injury to others given there was no passengers or no one in the other vehicle. So this was also accepted by the court, and in making penalties, setting down penalties, they took into account the evidence that we put before the court, the submissions that I gave to sway the court to deal with my client in a more lenient way than what he would otherwise be dealt with. My client ultimately was not given any financial penalty due to the fact of the situation that he is in and the financial disaster that he has brought upon himself. So that was one positive result that we obtained. No penalty involved. However, he was subject to a disqualification period for a minimum period of 6 months off the road, and that 6 months would commence from the date of the incident. So the time that he's been off the road since the incident occurred to today's court date will be taken into account as time already served off that 6 month period. Mandatory laws came in for high range offenders to enter into an interlock period for a minimum of 2 years. Those new laws came in as of the 1st of February this year in 2015. So he will be subject to those interlock laws once he has the opportunity of getting his licence back. The court did see fit to put my client on a good behaviour bond under Section 9 of the Crime Sentence and Procedure Act, which basically means he needs to be of good behaviour for the next 12 months. If he does break the law again within that period, then he can be resentenced on this particular charge that was before the court today. But I'm confident that my client has learned some significant lessons coming out of this whole ordeal and incident, and he's certainly on the right to a more positive future. So these were some good results that we obtained today. Generally, someone with such aggravating features at a high range level could be in line for a lengthy time of community service or even a suspended jail sentence. But we were able to sway the court to deal with this matter by way of a simple good behaviour bond, a no financial penalty, and the minimum period of time off the road for his disqualification. So guys, if you have found yourself in the unfortunate situation where you have been charged with a drink driving offence or an alcohol-related traffic offence, or any sort of traffic or criminal offence for that matter, please feel free to give me a call. My name's Josh Boorman from Waverley Local Lawyers. You can contact me at the office on 02 9283 8622, or I'll about laws. You might want to make yourself a fay with your position or situation that you're in before giving me a call. I'm happy to have a free first telephone consult with you just to give you an idea of what your situation is and how we can possibly best prepare for your court case. Fuck's sake. Sorry. So feel free to give us a call on 02 9283 8622. Thanks for tuning in, guys.